Welcome, everyone. Welcome to the Richmond Rent Program's presentation on handling habitability problems. My name is John Adams, and I'm a rent service analyst or a housing counselor for the Richmond Rent Program. Today's presentation will be on handling habitability problems in Richmond. Before we begin, there's one important piece of news that I want to make sure everyone is aware. During the last election cycle, the citizens of Richmond passed Measure P, and it went into effect on December 30th, 2022. For landlords, Measure P means that last year's initial annual general adjustment of 5.2 was allowed between its initial establishment in September through the enactment of Measure P on December 30th. Once Measure P became effective, it required that landlords must reduce the annual general adjustment from 5.2 to 3%. Any rent collected over 3%, for example, that 2.2%, would be considered a rent overcharge. For more information on Measure P, you may access the Rent Program's Rent Increase webpage seen on this slide. Now let's jump into the presentation on handling habitability problems. In this presentation, I'll first do a quick overview of the Richmond Rent Ordinance. Second, I'll go over key habitability laws, policies, and procedures. I will explain how these laws create rules and mechanisms to compel repairs. I'll go into detail about the tenant petition, which is the Richmond Rent Program's process to order the rent reduced until the repairs are made. And next, I'll discuss the connections between breaking the lease and habitability concerns. And fourth, I'll explain how habitability issues might affect the landlord's ability to raise the rent. Fifth, I'll explain the relocation ordinance, and then I'll examine Richmond's eviction protections laws and the connection between evictions and habitability issues. Finally, because it directly relates to fixing habitability issues, I'll go over the rules regarding landlord entry into a unit. By the end of this presentation, you should know the rights and regulations regarding habitability complaints, and if you are a tenant with habitability issues, then you should know what actions you can take to correct them. First, let's start with a quick overview of the rent ordinance. It's important to know which provisions of the rent ordinance apply to a unit. What options that are available for a tenant to handle a habitability complaint is directly related to which part of the rent ordinance apply to the property. There are three categories of residential rental properties in Richmond. The first is what we call fully covered. Fully covered means that both rent control and just cause for eviction protections apply to those units. Most multi-unit properties are fully covered. Rent control means that the rent ordinance and the rent board regulate the amount of rent that can be charged. Rent control empowers the rent program to order changes to the rent and offers both tenants and landlords reasons for which they may request, through our program, a change in the amount of rent collected. The second type of property is what we call partially covered. Partially covered means that only the just cause for eviction protections components of the rent ordinance apply to that unit. These properties include governmentally subsidized units, condominiums, and single-family homes, so long as there's no ADU or in-law unit. The third type of unit is what we call fully exempt. Fully exempt from all the provisions of the rent ordinance. Fully exempt means that those units are not subject to either rent control or just cause for eviction protections. Fully exempt rental units include those where the landlord and the tenant share a kitchen and/or a bathroom, and some nonprofit senior living residences. When determining which category your property might fall and whether there is rent control, the existence of an ADU is one of the most questioned scenarios. An ADU is defined as an accessory dwelling unit. Examples are converted garages or an in-law unit. ADUs transform a single-family home into a multi-unit property and may introduce rent control to both units, the ADU and the main house. This chart summarizes the most 5 common scenarios regarding ADUs. But if you are uncertain, I recommend contacting the rent program for advice. As I stated earlier, for fully covered or rent-controlled units, the Richmond Rent Ordinance and the Rent Board regulate the amount of rent that can be collected. Key to understanding that regulation is the idea of the maximum allowable rent. The maximum allowable rent is the maximum rent or the rent ceiling that a landlord may collect. The actual rent collected may be lower than the maximum allowable rent, but never higher. The maximum allowable rent is equal to the base rent, or the rent set at the initiation of the tenancy, plus the sum of all the annual general adjustments or allowable rent increases, plus any individual rent adjustments awarded through a petition. When it comes to habitability issues, the tenant may request through the rent program's petition process to lower either the actual rent or the maximum allowable rent. Now that we have a basic understanding of the rent ordinance and rent control, I'll now turn to explaining the laws and policies that define habitability and show how rent control offers a powerful option to addressing habitability complaints. Critical to understanding habitability issues in rental properties is to understand the implied warranty of habitability. The implied warranty of habitability means that the act of a landlord offering a unit for rent implies, even if not stated in the lease, that the landlord is offering a habitable unit that meets basic health and safety standards. These basic health and safety standards are defined through several California laws, several California Supreme Court rulings, and through multiple jurisdictions. For example, California State Civil Code 1941.1 defines the basic building standards required for landlords to offer and to maintain in their units. And California Health and Safety Code 17920.3 declares that a building will be deemed substandard if it does not meet the listed health and safety requirements. Richmond Municipal Code further mirrors the state habitability standards and further provides clarity and detail on what those standards mean. I'll now take a quick look at some of the details in common habitability complaints specifically enumerated in these laws. California Civil Code 1941.1 specifically states that a habitable unit must have the following: plumbing facilities in good working order, heating facilities in good working order, an electrical system in good working order, adequate trash receptacles in good repair, floors, stairways, and railings in good repair, working smoke detectors, natural lighting in every room through windows or skylights. Combining these specifically enumerated rules with the implied warranty of habitability means that, for example, if a landlord were to offer a unit for rent that had a faulty heater or the heater were not maintained through the tenancy, then the landlord would be responsible for adding a heater or fixing the heater. If they did not, the landlord would be in violation of the law. It must also not be ignored that the tenant is required by law, specifically California Civil Code 1941.2, to take reasonable care of the rented property and common areas. This means that the tenant must keep the rental unit in good condition. Any damage caused by the tenant or by the tenant's guests, children, or pets would become the responsibility of the tenant. For example, a tenant may not change the locks of a door without permission from the landlord, as that may be considered the removal or alteration of part of the landlord's property. Or, if a tenant's child flushes a sock down the toilet, the tenant may be responsible for the plumbing damage. Now that we understand to some degree the definition of habitability issues, next I will look at how a tenant can address those issues. There are 4 key steps that a tenant could take to addressing habitability problems. First, educate yourself. It's recommended for a tenant to educate themselves on their rights and responsibilities. This may start with a conversation with a rent program housing counselor like myself. Second, it's critical to document the problem or complaint in writing. The importance of documentation will come up again and again. Third, the tenant may request a housing inspection with the City of Richmond. Governmentally subsidized tenants, such as Section 8, may request an inspection from the Contra Costa Housing Authority. And fourth, if the unit is fully covered and there is rent control, then the tenant may file a rent reduction petition. If partially covered without rent control, then a tenant may request mediation through the rent program. Documenting the issues is of critical importance for 2 reasons. First, a landlord may not be held liable if they were not informed of the issue. Documenting the issue in writing proves that the tenant informed the landlord. Second, documentation is important because if the issue escalates to a court or petition, then the documentation can serve as evidence. Here are some basic tips for documenting issues. Tip number 1, tenants are encouraged to write letters or emails of habitability complaints to the landlord. Emails are particularly effective because they are easy to find and are date stamped. Photos and videos are also effective means to document the issue. Tip number 2, keep copies for your own records. You never know when you might need them. Tip number 3, if you are engaged in verbal communication, it's recommended that you summarize the conversation in writing. You can give a copy through an email to a landlord to avoid unnecessarily disputes and to have the verbal communication documented. Tip number 4, if the landlord is not responsible to legitimate complaints, the tenant may consider documenting the habitability problem through an inspection by the city. Tip number 5, dates are important. Think of it as creating a story. Using a chronological approach to memorialize the problems is important in framing the narrative. Tip number 6, the case may go to the rent board hearing or a court. Be mindful that anything you write may become part of the court action. Your credibility can be damaged if your letter appears unreasonable or abusive in tone. One important way to document habitability issues is through an inspection. A tenant may request a housing inspection by contacting the City of Richmond's Residential Rental Inspection Program. Their number is here. It is 510-690-8260. Section 8 tenants and governmentally subsidized tenants may contact Contra Costa Housing Authority for an inspection. Their number is 925-957-7023. Once an inspection is requested, it can take several days for the inspection to actually occur. An inspection will be set, and the inspector will come to the property and notify the landlord if code violations are found. The landlord may face fees or fines if they do not correct the violations. Alternatively, a tenant may call code enforcement. Code enforcement is the office that makes sure that owners maintain their properties to a minimum threshold of structural and health and safety codes. For example, any work done without a permit, construction work done without a permit, or the existence of urban blight, such as vermin, may be reported to code enforcement. Code enforcement has a website on the City of Richmond's webpage and may be reached by calling 510-621-1279. For rental units that are fully covered, one of the most effective means to deal with a habitability complaint is the tenant petition to reduce the rent. The petition may not only reduce the rent, but may compel the landlord to correct habitability problems as their income may be impacted. A tenant can petition to reduce their rent if the following criteria are met. The tenant resides in a fully covered rental unit. There is, in fact, a decrease in habitability or reduction in space or services that can be proved. And third, the landlord has been informed about the problems. Remember the importance of documenting everything. Tenants who live in partially covered or fully exempt properties cannot file petitions to reduce their rent because those properties are not regulated under rent control. Tenants in partially covered units or fully exempt units may request mediation through the rent program to try to resolve their issues with the landlord. The petition process works as follows. A tenant would file a claim against the landlord. The best claims have documented evidence and a set of dates chronicling the issues with the landlord. Once the petition is filed, the landlord will be given the opportunity to tell their side of the story and to offer their supporting evidence. Once both sides have had the opportunity to offer their evidence, a date will be set with a hearing examiner. The hearing examiner acts as the judge of the case. On the day before the hearing examiner, there are generally two possible outcomes. First, the tenant and the landlord may come to an agreement or a settlement about the issues. For example, a landlord may offer several months of free rent while he fixes the habitability complaints. Or two, if the tenant and the landlord are unable to come to an agreement, then the hearing examiner is empowered to alter the rent as he sees fit. For example, for a broken heater, the hearing examiner may order 20% of the rent to be refunded for the past 6 months and 20% of the rent to be reduced moving forward until the heater is working properly. With no reached agreement, the rent ordinance empowers the hearing examiner to decide changes to the rent. He will do so by applying the law, assessing the evidence, and listening to the tenant and the landlord. A decision by the hearing examiner may be appealed by either the tenant or the landlord by bringing the decision before the rent board. When habitability issues exist, it may also affect the ability of the landlord to raise the rent and act as he would under normal circumstances. In rent-controlled units, the rent order further regulates habitability issues by creating consequences for unabated habitability issues. For example, the hearing examiner may order a denial of the landlord's annual general adjustments. Or if a unit is vacated because of a habitability issue, the rent board may consider that vacancy as non-voluntary. A non-voluntary vacancy remains under rent control, meaning even though the tenants left the unit, the rent-controlled levels could remain in effect and transferred to the next tenant. For all units, including partially covered units, California Civil Code 1942.4, again, 1942.4, prevents a landlord from demanding rent, collecting rent, issuing a notice of rent increase, or issuing a 3-day notice to pay the rent or quit when all of the following 4 factors exist. First, the rental unit must be in violation of habitability, as stated in Civil Code 1941.1, as we saw earlier, or Health and Safety Code 17920.3. The unit must have been inspected by a public officer, such as an inspector from code enforcement, and that officer had cited the owner. The condition continues to exist for 35 days after the inspector's notice. And fourth, the condition was not caused by the tenant. If these 4 factors exist, California law effectively disallows the landlord from raising or even collecting the rent. If the habitability issues are too severe, or if after all the tenant's efforts, the landlord continues not to properly abate the issue, then the tenant may feel they have no choice but to break the lease. I'll now go over the rules and laws regarding breaking a lease. Generally speaking, under normal circumstances, if a tenant breaks a lease with a term still remaining, they may be liable for the unpaid rent for the remainder of that term. For the landlord to collect that rent, they would need to fulfill certain responsibilities. The most important or the most difficult claim for the landlord to fulfill to make a claim for unpaid rent is that the landlord must first make reasonable effort to re-rent the unit. If a landlord can show reasonable effort to re-rent the unit, then they may argue that the tenant owes the remainder of the rent through the term. On the other hand, if a tenant vacates a rental unit due to a habitability problem, the law may allow them to end their tenancy without giving 30 days written notice. It may be argued by the tenant that the habitability issue is in fact the landlord breaking the lease. As we covered earlier, the implied warranty of habitability says that in every lease that the landlord is responsible to maintain the unit. If a habitability issue exists, it can be argued that the landlord is not maintaining their side of the lease. If the landlord has broken the lease, then the tenant may vacate without being liable for the remaining months on the lease. Ultimately, if the tenant breaks the lease, then a landlord may take them to court for violating the lease. and the tenant may in turn offer the habitability issue as their defense or reasoning for breaking the lease. The final decision would be made in court. For rent-controlled units, as we have seen, the petition process offers an alternative to breaking the lease. For partially covered units, mediation becomes an option to resolve habitability problems. Mediation is a voluntary process by which the rent program works as a bridge to attempt to broker an agreement between the two parties. This agreement is voluntary and often requires both sides to compromise to get to a position where the issues can be reasonably resolved. When a tenant leaves a unit due to a habitability issue, they may be entitled to payments for relocation. Richmond has a second law titled the Relocation Ordinance, and under some circumstances may require the landlord to pay the tenant to be out of the unit. There are two types of relocation, temporary and permanent. Temporary relocation is generally paid when the landlord undertakes repairs or abatement that requires the tenant to leave the unit so that those repairs may be made. For example, a landlord may need to turn off the water system for a week in order to repair a unit. In this instance, the landlord would relocate the tenant until the issues are fixed. Then the tenant would return to the unit. Additionally, if the habitability conditions are such that a tenant deems the unit uninhabitable, then the tenant may do two things. The tenant may call code enforcement and ask for an inspection, and code enforcement may order the tenant to vacate the unit. Or second, the tenant may choose to vacate on their own accord. An example of a condition where a tenant might need to vacate a unit could be due to a safety condition caused by a flooded sewer. Temporary relocation amounts are set by law and are on a schedule that I'll show in the next slides. Permanent relocation is paid when the temporary relocation period ends. For example, if the tenant is temporarily relocated for over 120 days, the tenant may choose to find new accommodation. In this case, the permanent relocation would be paid to assist with the displacement costs. These amounts are also set by law and on a schedule that I'll show in the next slides. Here we see the legally mandated amounts of temporary relocation. The landlord would, if the tenant required temporary relocation, the landlord would pay the tenant $178.24 per day for hotel or motel accommodations. There's also a meal expense paid per person per day and a laundry expense, as well as pet expenses. There are two types of permanent relocation, and which amount required would depend on the circumstances of the situation. The first amount is called relocation due to owner move-in. The owner move-in amounts would often be used if the end result of the situation is that the owner decides to repossess and live in the property themselves. These amounts vary from $4,177 to $10,072, depending on the size of the unit and who the tenants are. And finally, shown here are the amounts of permanent relocation that would be required if there is an order from a government agency, such as code enforcement, to vacate the unit. These amounts also vary depending on the size of the units and who the tenants are. When relocation is required and how much relocation is required is not always straightforward. If you have questions, it's always advisable to contact a rent program, housing counselor, or an attorney. In addition, just as there is a petition for habitability issues, there is also a petition for failure to pay relocation payments. Since relocation is tied to eviction and vacating a unit and not rent control, this relocation ordinance may be utilized by tenants in partially covered units. Evictions. So a landlord's ability to evict a tenant may also be tied to habitability issues. First, I'm going to begin by going over Richmond's just causes for evictions, and then I'll explain how habitability complaints might affect the eviction process. In Richmond, a landlord may only evict a tenant if they're able to cite and support one of 8 just causes for eviction. The first 4 causes are what we call at-fault causes, where the tenant has performed a behavior that causes them to be evicted. These 4 are failure to pay rent, breach of the lease, nuisance, and failure to allow the landlord entry into the unit to fix problems. The second 4 allowable evictions in Richmond are no-fault evictions, where the landlord may undertake the eviction by virtue of being the owner. The first is a temporary eviction in order to undertake substantial repairs. The second is the owner moves in and lives in the unit themselves. The third is the withdrawal from the rental market. And the fourth is temporary tenancy. 3 of these evictions, the temporary eviction in order to undertake substantial repairs, the owner move-in, and with the withdrawal from the rental market, all require relocation payments. The first connection between evictions and habitability issues is nuisance. Nuisance is a just cause for eviction, and therefore a reason a landlord may proceed with the eviction proceedings. Part of the definition of a nuisance is that a tenant is engaging in behavior that might affect the health, safety, and habitability of their unit and/or of their neighbors. For example, smoking is banned in most rental units in Richmond. If a tenant smokes in the unit, the landlord may argue that smoke damages the unit, such as destroys the carpet or the curtains, and/or endangers the health and habitability of their neighbors. By affecting the habitability of their neighbors or unit, that tenant may be evicted as a nuisance. It is important to note that if a landlord attempts to undertake a nuisance eviction or a breach of lease or a failure to give access eviction, then the landlord must issue 2 written warning notices. The first notice is a notice to cease. In this notice, the landlord should describe the behavior and what the tenant can do to fix the issues. If the tenant fixes the issue, then the problem is considered resolved. The second notice is a notice to cease or quit. This is a termination of tenancy notice. This notice should also describe the behavior and how the tenant can fix the issue, but it also states that if the tenant is unwilling to change, then the landlord may use this notice to initiate the eviction proceedings. Finally, the connection between eviction and habitability problems is that the existence of a habitability problem may be used as a defense to an eviction lawsuit. Meaning that if a tenant has informed the landlord of the existence of a habitability issue, those issues may prevent the landlord from successfully evicting a tenant. Essentially, the landlord has not followed the law, and an eviction may not be ordered if the landlord is not following the law. Finally, since we're discussing habitability issues, I'll explain the rules regarding landlord entry into a unit. If a tenant informs the landlord about a habitability problem, it becomes the landlord's obligation to make the necessary repairs. This gives the landlord the right to enter the rental unit to make repairs. In order to enter a unit, the landlord must give the tenant a 24-hour written notice of intent to enter. This notice should state the general time that the landlord intends to enter, who is entering, and for what purpose. The tenant may request to be present, but does not have the right to demand to be present. If the tenant refuses to allow the landlord to enter, then the tenant should be aware that this is a just cause for eviction, and the landlord may evict them for failure to give access. Essentially, it is the landlord's responsibility to maintain a habitable unit, and the landlord cannot prevent them from doing, and the tenant cannot prevent them from doing so. On the other hand, if a landlord violates or abuses the entry requirements, then the landlord may be liable to penalties and may lose the right to reset the rent to market when the unit is vacated. California Civil Code 1954 is the law that regulates landlord entry. It's important to know that in addition to allowing the landlord to enter for repairs requested or require, the landlord may also enter for other reasons. The landlord may enter the unit without notice in case of emergency, such as a flood. The landlord may enter when the tenant has abandoned or surrendered the premise. The landlord may enter due to a court order. They may enter to check water submetering. They may enter to show the property to potential buyers. And they may enter to maintain smoke detectors in balconies. If you have questions about landlord entry, feel free to reach out to a housing counselor at the Richmond Rent Program. So thank you, everyone. This concludes our presentation on handling habitability issues. So thank you for joining me. And if you have further questions, we'll take a few minutes to answer your questions now. Please be aware that we will only answer general questions and nothing specific to a certain property or situation. You can always call the Richmond Rent Program or visit our website if you have questions. If you have a question, please raise your hand. If you don't know how to do that, I'm not sure. Okay. All right. So, Miss Lee, you should be able to speak. Can we hear you? Hmm. 1 second. So you could go ahead, Parsi Lee. Oh, well, you can also put the question in the chat. You should see a question and answer box if you'd like to type a question, and or a chat box. And if you raise your hand, I'll give you permission to speak if your microphone is working. So the question is, does the owner entry include when a seller is selling their property? So the answer is yes. So one of the rights that a landlord has is to sell the property, and that allows them entry into view the property to potential buyers. So they should give you the written warning notice telling you that they're coming. That should include the reason, stated, to show the property, but the landlord does have the right to enter to show the property to prospective buyers. And if that doesn't answer your question, feel free to elaborate. I'll leave the second, if a seller, so the second question is, or follow-up is, what should a seller do if a tenant refuses to comply? So this is where there is a process. So that's the written warning process. So as I said, failure to allow entry for allowable reason is a just cause for eviction, and the eviction process has certain steps on it. So a seller could formally offer the notices to cease the behavior, and if this behavior continues, to cease or quit, and then engage in the eviction process. You could also informally, try to work with the tenant and see if there's a reason, or maybe they want to be present. So it's sort of, those would be the best answers I could give at this time. I'll leave the questions open for about a minute or two, and if there's none, then we'll end the webinar. Yeah, I'm gonna go. Well, I don't see any more questions. So thank you all for joining us today. Always feel free to reach out to the Richmond Rent Program. We're here to help and serve the community. And I hope everyone will have a fun and safe Halloween. Yeah.